600 people lost water that morning, not for an hour, for 11 days. Barbara cut that line with a $40 angle grinder because the pipe ruined her sunset photos. She didn't know the pipe wasn't mine. It wasn't even the county's. That water belonged to a nation that has held title to it since 1868, and treaties, unlike HOA bylaws, are the supreme law of the land. This is the Navajo Nation. A sovereign territory larger than West Virginia, home to more than 250,000 people. And right now, 30% of them do not have running water, not because of drought, not because of poverty, because for 155 years, the United States has found legal loopholes to avoid honoring a treaty it signed in 1868. Barbara didn't just cut a pipe. She walked into a fight most Americans do not even know is still raging. Here is how one act of petty vandalism exposed a theft that has been happening in plain sight for more than a century. The morning the water stopped, the elders thought it was a pump failure, a busted valve, something routine on a reservation where infrastructure is held together with baling wire and prayer. But when tribal police arrived, they found the main supply line into Black Mesa had been severed deliberately, a clean cut. Beside the pipe, a single business card from the Desert Mesa Homeowners Association. On the back, written in Sharpie, "Your pipe ruins my view, relocate it or I will." That line fed 612 people, elderly diabetics on dialysis, infants on formula, a clinic with no way to sterilize equipment. Barbara Keene used a $40 angle grinder because she thought she was dealing with a county utility, a minor inconvenience she could fix before book club. But Barbara had not cut a county pipe. She had severed a federal trust water line protected by the 1868 Treaty of Bosque Redondo, the document that ended the Navajo Wars, returned the Dene people to their ancestral homelands, and guaranteed them, under the Supreme Court's own precedent, enough water to make that homeland permanent. Most Americans do not understand what that treaty actually meant. It did not give the Navajo water as a gift. Recognized water that was already theirs. For centuries, the Dene had farmed the floodplains of the San Juan and Little Colorado rivers. They built intricate irrigation systems. When General William Tecumseh Sherman signed in 1868, he was not granting rights. He was acknowledging a theft the United States had already committed and promising to stop. He lied. By the 1960s, water that should have flowed to Navajo families was being pumped to coal mines at Black Mesa. 3 million gallons a day siphoned from the Navajo aquifer to slurry coal hundreds of miles to power plants in Laughlin, Nevada. Those plants generated electricity for Las Vegas casinos, for swimming pools in Scottsdale, for air conditioners in Phoenix. And on the reservation, springs that had bubbled for millennia began drying up. Families who had lived on that land for generations suddenly drove 80 miles round trip to fill plastic barrels with water that cost 20 times what their neighbors paid in town. This is not ancient history. Right now, more than 100,000 Dene citizens still haul water to survive. On average, they use 7 gallons per person per day. The typical American household uses 100. You do the math. In June of 2023, the United States Supreme Court weighed in. The Navajo Nation asked the federal government to simply assess what water they needed and make a plan, not to dig wells immediately, just to figure out what a permanent homeland requires. In a 5-4 decision, the court said no. Justice Brett Kavanaugh wrote that the treaty implies water rights but does not require the government to lift one finger to actually provide them. So the federal government can acknowledge you have water rights while standing back and watching you die of thirst. That is not a contradiction in the law. That is the law. When Barbara Keene cut that pipe, she triggered a federal investigation, not just into her vandalism, but into the entire legal architecture that allowed a private citizen to sever a sovereign nation's water supply. Because here is the question the United States suddenly had to answer. If a random HOA president can destroy a tribal water line and suffer no immediate consequence, what exactly does tribal sovereignty mean? That investigation led tribal attorneys to a dusty filing cabinet in the Bureau of Indian Affairs Regional Office in Phoenix. Inside, they would find a letter from 1957, proof that the Navajo's water had been stolen not by accident, but by design. When you hear what that letter said, you will understand why the fight for water on the Navajo Nation is the most important civil rights battle nobody is talking about. The letter was dated March 11th, 1957. It sat inside a manila folder so old the paper had turned the color of weak tea. No one had requested it in 66 years. A tribal paralegal named Lena Begay found it while searching for water rights documentation, not because she knew what she was looking for, but because the federal government had produced 47,000 pages in discovery, and she was the one tasked with reading all of them. The letter was from a Bureau of Indian Affairs hydrologist named Harold T. Rennick to the regional director in Gallup. It was classified as internal correspondence, which meant it was never shared with tribal leadership. For 6 decades, it simply disappeared into the archive. Rennick had been sent to survey the aquifer beneath Black Mesa in 1956. His job was to determine whether the groundwater was sufficient to support a proposed coal mining operation. The mine would require at least 2.5 million gallons of water a day. So Rennick spent 8 months testing wells, measuring recharge rates, mapping the underground basin. His conclusion, buried on page 3 of this letter, was unambiguous. The Navajo aquifer beneath Black Mesa is recharged at approximately 110,000 acre-feet annually. Of that, approximately 90,000 acre-feet are required to sustain current and projected tribal domestic use through the year 2000. Extraction for commercial purposes beyond 10,000 acre-feet annually will result in aquifer depletion within 4 decades. Then he wrote the sentence that made Lena Begay stop breathing. I understand that Peabody Coal's proposed extraction rate of 900,000 acre-feet annually will far exceed sustainable yield. I also understand that my findings are unlikely to alter departmental enthusiasm for the project. Please advise whether I should revise my conclusions before submitting the official report. He was asked to lie, in writing, by his boss. Lena Begay read that letter 3 times. Then she walked it down the hall to the office of Michael Laughter, the Navajo Nation's lead water rights attorney. Michael Laughter is 53 years old, a Harvard Law graduate who could have billed $800 an hour in a Manhattan corner office, but instead came home to Window Rock to fight for the water his grandmother died without. When Lena handed him the letter, he read it in silence. Then he removed his glasses. Then he said something that cannot be repeated in this video, because here is what that letter meant. It meant that in 1957, the United States government knew, with geological certainty, that allowing Peabody Coal to pump water from the Navajo aquifer would drain the reservation dry within 40 years. They knew it would kill springs. They knew it would force families to abandon homes. They knew it would condemn tens of thousands of people to water poverty. And they did it anyway. Between 1966 and 2005, Peabody Coal removed more than 1.3 trillion gallons of water from the Navajo aquifer. That is enough water to fill 2 million Olympic swimming pools. That is enough water to supply Phoenix for 50 years. And on the reservation, families watched their wells turn to dust. Entire chapters of Dene life, farming, sheep herding, traditional medicine, were extinguished so that air conditioners could hum in suburbs built on stolen water. Michael Laughter assembled a legal team that weekend. He called Phoenix. He called Denver. He called the Department of Justice. He informed them that the Navajo Nation was preparing to file a motion for sanctions based on deliberate concealment of material evidence, the Rennick letter, in the ongoing water rights litigation. The federal response arrived 3 days later. Not a phone call, not a legal filing. A letter from the Bureau of Indian Affairs announcing a compliance review of all existing water infrastructure grants to the Navajo Nation. Total value, $147 million. The letter stated that funding continuity cannot be guaranteed pending resolution of the tribe's litigation posture. Translation, drop this, or we will cut off the money your people need to survive. This is how the game works. You discover evidence that the government destroyed your water supply. In response, the government threatens to withhold the money you need to truck in emergency water. You are being punished for proving you were robbed. But the tribal council did not drop it. They voted unanimously 24-0 to proceed, and they made a decision that would transform this from a legal fight into something far more dangerous. They decided to follow the money. What Lena Begay discovered next made the Rennick letter look like a parking ticket. While investigating the corporate structure behind Desert Mesa, Barbara's HOA, she found that the subdivision had been built in 1994 on land that, until 1983, had been part of the Navajo reservation. Congress had removed it. A quiet piece of legislation called the Navajo Hopi Land Settlement Act, which was supposed to resolve a border dispute, somehow transferred 4,000 acres of historically Navajo territory to private developers. No payment, no negotiation, just a line on a map. And the company that developed that land, Southwestern Water Resources Incorporated, a subsidiary of Peabody Energy, the same company that drained the aquifer, the same company that asked Harold Rennick to falsify his report. They did not just steal the water, they stole the land the water sat beneath. Then they sold it to people like Barbara Keene, who had no idea the soil under her desert landscaping was soaked in a crime. Barbara was not just an HOA president with an angle grinder. Barbara was the final link in a 60-year chain of federally sanctioned theft. When she cut that water line, she unknowingly attached her name to a conspiracy that reached from Window Rock to Washington. And here is where it gets even stranger. After cutting the line, Barbara was not arrested. The county sheriff showed up, took a report, and left. When tribal police attempted to file charges under federal law, vandalism of a tribal utility is a federal crime. The U.S. Attorney's Office in Phoenix declined to prosecute. They declined. The same Justice Department that had just threatened to cut off water funding to the tribe. They said Barbara Keene's actions did not meet the threshold for federal prosecution. An act of vandalism that cut off water to 600 people, including an elder who went into renal failure because she could not access dialysis, and the federal government said it was not serious enough. Michael Laughter filed a Freedom of Information Act request for the declination memo 3 days after the Thanksgiving holiday. When the response arrived, it was heavily redacted. Entire pages were blacked out under claim of deliberative process privilege, but one line was left visible. It was from an internal email between the U.S. Attorney and someone at the Department of the Interior. The line read, "Prosecution would risk exposing prior agency knowledge." They were protecting the letter. They knew the Rennick letter existed, and they knew that if Barbara Keene went to trial, the tribe's defense attorneys would have grounds to subpoena the entire BIA archive. The Justice Department was not declining to prosecute a vandal. They were declining to open a door that could not be closed. That was when Michael Laughter realized he was not fighting a legal case. He was fighting a cover-up. He called a press conference on December 18th at the Tribal Council chambers in Window Rock. Standing in front of a photograph of the severed pipeline, with elders behind him holding empty water jugs, he said 6 words that made national news. "We are filing a federal tort claim against the United States government for constructive fraud and deliberate continuation of a known injury." Legal translation. The tribe was suing the federal government not just for violating the treaty, but for lying about it. For knowing the water theft would cause harm, hiding that knowledge, and letting people suffer for decades while the government professed helplessness. The Department of Justice had 30 days to respond. On day 29, they filed a motion to dismiss, arguing sovereign immunity, the legal doctrine that says you cannot sue the government unless it lets you. The same government that signed the 1868 treaty. The same government whose Supreme Court had just ruled that treaties require no affirmative action to protect tribal water. The same government whose own hydrologist warned them in 1957. Lena Begay worked through Christmas that year. She was tracking something new. The water that had been pumped from the Navajo aquifer for 40 years, it did not just disappear. It went somewhere. It was sold to cities, to golf courses, to agricultural operations in California. Billions of gallons of Navajo water generated revenue, and the tribe never saw one penny. She started building a spreadsheet. Line by line, she traced the money. And what she found at the end of that paper trail was about to turn this from a civil lawsuit into something else entirely. Because the largest single buyer of Peabody's Navajo water turned out to be a public entity that every single taxpayer in America helps fund. When you hear who it was, you will understand just how deep this goes. The largest single buyer of Peabody's Navajo water was not a private corporation. It was a public entity you have been paying for since 1968, the Central Arizona Project. 336 miles of concrete canals, tunnels, and pipelines that pump Colorado River water uphill to Phoenix and Tucson, the largest and most expensive aqueduct system ever built in the United States. Funded by federal taxpayers, operated by the Bureau of Reclamation, the same bureau that is supposed to protect tribal water rights. Here is how the money moved. Peabody Coal pumped Navajo groundwater to slurry coal to the Mojave generating station. The electricity from that plant powered the pumps that lifted CAP water out of the Colorado River. So Navajo water, extracted at a rate 40 times the sustainable yield, was literally used to deliver water to the subdivisions and golf courses that were spreading across the Arizona desert. And the Navajo Nation was not just uncompensated. They were actively excluded from the CAP allocation formula. Not 1 gallon of CAP water was ever set aside for the reservation, even as the project used stolen Navajo water to fill swimming pools in Scottsdale. Lena Begay's spreadsheet tracked the payments. Between 1985 and 2005, the Bureau of Reclamation purchased approximately 420 billion gallons of water from Peabody Coal's slurry operation through intermediary contracts. The payments were laundered through 3 shell corporations. The final destination of the money was a capital improvements fund managed by the Department of the Interior. That fund was used to build additional CAP pumping stations. So the government used stolen water to power the project that then provided cheap water to cities and used the profits to expand the theft. This was not incompetence. This was a business model, and the Rennick letter proved that every single agency involved knew the aquifer would collapse. Michael Laughter spent January assembling a filing that would have terrified any private corporation, a racketeering complaint under the Racketeer Influenced and Corrupt Organizations Act against the Bureau of Reclamation, the Department of the Interior, and 3 former officials still drawing federal pensions. He had bank records. He had internal memos. He had the 1957 letter advising a hydrologist to falsify his conclusions. He had enough to force discovery on a scale the government had never faced. Then on June 22, 2023, the Supreme Court released its decision in Arizona versus Navajo Nation. 5-4. Justice Kavanaugh writing for the majority. The federal government has no affirmative duty to assess the Navajo Nation's water needs or to provide water under the 1868 treaty. The same justice who wrote that the treaty implies water rights also wrote that the judiciary cannot compel the government to actually do anything about it. The tribe could have the right. They could have the proof of theft. They could have a dying aquifer, a population surviving on 7 gallons a day, and letters from the government's own scientists warning of disaster. And the court's answer was, we see no duty here. Within hours of the ruling, the Bureau of Indian Affairs terminated the compliance review and unfroze the infrastructure grants. The message was unmistakable. The Tribal Council could continue litigating, but there would be no more leverage. The Supreme Court had just declared that the government owed them nothing. Michael Laughter called Lena that night. He told her he was considering settling for a fraction of the damages. He sounded like a man who had run out of road. But Lena Begay had not stopped reading. While the Supreme Court was deliberating, she had been following a different thread. The water that Barbara Keene's neighborhood used, the same water Barbara cut off from the reservation, was supplied by a small municipal utility called Desert Basin Water District. And Desert Basin's senior water rights, recorded in 1985, were derived from a state permit that explicitly listed the source as unappropriated groundwater. Unappropriated. Meaning nobody owned it. Meaning it was free for the taking. But Lena found the original hydrographic survey from the Arizona Department of Water Resources. The survey showed, in 1984, that the groundwater in question was part of the Navajo aquifer and was already fully appropriated to the Navajo Nation under the Winters Doctrine. The state of Arizona had simply declared it unappropriated anyway. They had erased the tribe from their own paperwork. And when the Bureau of Indian Affairs was asked to certify the water right transfer, they signed off without objection. Another cover-up. And here is where Barbara Keene re-enters the story, because Lena, in her research, found that Barbara's husband, Richard Keene, had been a mid-level administrator at the Arizona Department of Water Resources from 1981 to 1993. He had personally signed 3 of the permits that reclassified Navajo groundwater as unappropriated. He knew the Keenes had moved into Desert Mesa in 2006, retired, and Barbara had spent the next 17 years harassing the tribal utility about the aesthetic blight of the water line crossing what she believed was her view corridor. She thought she was a property rights crusader. In reality, she was the heir to a fraud her husband had helped engineer. When tribal investigators contacted Richard Keene in February of this year, he initially refused to speak. But he was 79 years old, in poor health, and facing the prospect of being named in a federal racketeering suit. After 3 interviews with his own attorney present, he agreed to provide a sworn affidavit. In that affidavit, he admitted that the reclassification of Navajo groundwater was a deliberate policy directed by the state land commissioner to support the CAP water transfer system. He also confirmed that the Bureau of Indian Affairs regional director had verbally approved the scheme in a closed meeting in 1986. That director was still alive. His name was Darren Holcomb, 87 years old, living in a retirement community in Sedona. Lena flew to Sedona with a court reporter. Holcomb answered his door, saw the subpoena, and started talking without being asked a single question. He said he had been waiting 40 years for someone to knock. He had kept diaries documenting every meeting, every directive, every time his superiors told him to prioritize regional development over tribal concerns. He handed over 12 leather-bound volumes. Those diaries contained the names of 3 sitting federal judges, 2 retired senators, and a former deputy secretary of the Interior, all of whom had participated in the decision to conceal the aquifer depletion projections. They contained reference to a secret Interior Department legal opinion issued in 1972 that acknowledged the Winters Doctrine gave tribes senior water rights, but argued that national energy security concerns justified prioritizing coal slurry operations over tribal domestic use. That opinion was never published. It was explicitly kept out of the Federal Register, because if it had been made public, the Navajo Nation could have sued immediately and won. The whistleblower Lena needed was not inside the Bureau of Reclamation. The whistleblower was the system's own architect, a man who had spent 35 years carrying guilt and finally saw a chance to unload it. Michael Laughter took the diaries and the affidavit to the U.S. Attorney's Office in Phoenix. He did not file a motion. He did not request a meeting. He walked into the federal building with a single banker's box, set it on the intake counter, and informed the duty officer that he was delivering evidence of a 60-year criminal conspiracy involving multiple federal agencies. The U.S. attorney who had declined to prosecute Barbara Keene, a man named Vincent Caruso, now faced a choice. He could either open a grand jury investigation into the same Department of Justice he worked for, or he could explain to a federal judge why he had suppressed evidence that a private citizen had just hand-delivered in a box. He had 48 hours to decide. On the morning of the deadline, Caruso called Michael Laughter. His voice, Michael later said, sounded like a man who had not slept in 4 days. He asked one question: how many of my colleagues knew? Michael's answer would determine whether this story ended in a courtroom or a congressional hearing, because what those diaries revealed about the federal government's relationship to Navajo water was not just criminal, it was structural, and once it became public, there would be no walking it back. Michael's answer to Vincent Caruso was 4 words, all of them, eventually. He handed over the diaries, the Rennick letter, Richard Keene's affidavit, and Lena's spreadsheet tracing every dollar of stolen water revenue. Within 72 hours, Caruso recused himself and forwarded the file to the Office of the Inspector General at the Department of the Interior. By the following Monday, the file was no longer in Phoenix. It was in Washington. On the desk of an assistant attorney general who had never even been to the Navajo Nation, but suddenly had to explain why her department had suppressed a hydrologist's warning for 6 decades. The Inspector General's report took 8 months. When it was released in September of this year, it was 412 pages long. Its primary conclusion was that the Bureau of Indian Affairs, the Bureau of Reclamation, and the Arizona Department of Water Resources had engaged in a coordinated pattern of deliberate administrative obfuscation, that is the exact phrase, to deny the Navajo Nation access to water its own treaty guaranteed. The report confirmed that the 1957 Rennick letter had been classified and buried. It confirmed that groundwater reclassification permits had been falsified. It confirmed that CAP water allocations were designed to exclude the tribe, and for the first time in a century and a half, a branch of the United States government used the word reparations. It recommended a figure, $2.6 billion, for infrastructure, for damages, for the cost of hauling water for 2 generations while the federal government knowingly drained the aquifer. The recommendation is not binding, but the report itself is public record. So is the deposition of Richard Keene, so is the 1957 letter, so are the diaries of Darren Holcomb, who died in hospice 2 weeks after his deposition, having finally told the truth. His family released a statement, "Our father spent his final years waiting for someone to ask. We are grateful they finally did." Barbara Keene pled guilty to misdemeanor criminal damage in tribal court. She paid a fine of $10,000 and was sentenced to 200 hours of community service. Her community service assignment was hauling water. Every Saturday for the next year, she will drive a truck with 2 plastic tanks to a filling station and deliver it to elders who cannot make the trip themselves. The tribal judge told her, "You severed a lifeline, now you will help carry it." The 89 families of Desert Mesa still have water. That part did not change. But the water district was required to renegotiate its rights settlement with the Navajo Nation, and those negotiations are ongoing. For the first time, the developer is at the table, not above it. Now here is the detail that changes how you should think about this entire story. The Rennick letter was not actually hidden in a classified archive. It was filed in a standard Bureau of Indian Affairs records box in Phoenix, accessible under the Freedom of Information Act, catalogued and searchable. Nobody ever requested it, because nobody believed the government would keep a smoking gun in an open filing cabinet. Lena Begay requested it by accident, checking a box on a form because she was working late and needed something to read. The government did not bury the evidence. They buried it in plain sight, knowing that a system which produces 47,000 pages of discovery is a system designed to exhaust the people who dare to read. The central insight of this story is not that the government lied. Governments lie. It is that the truth was always available, and nothing happened until one woman, a paralegal from a law firm in Window Rock, sat down and read the mail. Lena Begay still works for the Navajo Nation. She does not give interviews. She said she has more boxes to get through. Michael Laughter is still in litigation. The $2.6 billion recommendation may take years to turn into money. But the pipeline that Barbara Keene cut is functional again, repaired within 48 hours by tribal crews who have learned to move fast because every day matters. The elder who went into renal failure, her name is Mary Tsosi, age 73, received emergency dialysis at a clinic in Flagstaff. She is still alive. She keeps a 55-gallon drum of water in her yard now, just in case. When they asked her what she wanted white America to understand, she said this: "We are not asking for charity. We are asking for what was already promised. My great-grandfather signed that treaty. His signature is on the paper. I have seen it. It hangs in the chapter house. He gave his word and the United States gave theirs. Only one of us kept it. Here is the thing about the 1868 treaty. It does not expire. It has no sunset clause. It says the Navajo shall have a permanent homeland and permanent means until the rivers stop flowing. The rivers have not stopped flowing. They are just flowing to the wrong addresses. This is not just a story about water. It is a story about what a treaty actually means when the people who signed it are no longer alive to enforce it. The 1868 treaty was written on paper, signed with ink, and ratified by the Senate. No one has repealed it. No one has amended it. It simply sits in the National Archives, while 30% of Navajo households still haul their drinking water in plastic barrels strapped to pickup trucks. The $2.6 billion reparations recommendation is not a law. It is a suggestion from an inspector general, and Washington is very good at ignoring suggestions. But the documents are now public. The Rennick letter, the diaries, the falsified permits, they are no longer buried. They are on the record. And that matters because the next time a developer cuts a pipe or a state reclassifies groundwater or a judge rules that treaties imply rights but require no action, someone will be watching. Someone will be reading. Mary Tsosi is still alive. So are thousands of elders who remember when the springs ran clear and the sheep drank from streams that have since turned to dust. They are not asking for pity. They are asking for a contract to be honored. A contract that cost them 90% of their ancestral land and was supposed to guarantee the remaining 10% would have enough water to sustain life. Here is my question for you. Have you ever discovered that something you were promised was quietly taken off the table? A contract that was ignored, a rule that applied to you but not to them, a system that worked perfectly for everyone except the people it was built to protect? Drop that story in the comments. I read them. And if this episode made you think differently about whose water comes out of your tap, share it with someone who needs to understand. Next week, another story about the little guy who found the receipts. This time, a city council denied a business permit, so the owner found a bylaw from 1902 that made them untouchable. You will want to see that one. Hit subscribe, stay curious, and never, ever stop reading the fine print.